Welcome to this presentation on California Senate Bill 464, the new pay data and DEI reporting rules for 2026. I am your narrator, and over the next several minutes we will explore what this law means for employers across the state of California. As stated on the official website of the California Civil Rights Department at calcivilrights.ca.gov, SB 464 was signed into law by Governor Gavin Newsom on October 13, 2025. It amends California Government Code Section 12999, building on the framework established by Senate Bill 973 in 2020 and Senate Bill 1162 in 2022. Together, these laws create the nation's most robust pay data reporting system, and SB 464 takes it even further with three major changes. First, penalties are now mandatory. Where courts previously had discretion and may impose penalties, SB 464 changes this to mandatory language. Courts shall impose penalties upon request from the Civil Rights Department. Second, demographic data used for pay reporting must now be collected and stored separately from employees' personnel records, creating new data privacy obligations effective January 1, 2026. And third, the law expands from 10 EEO-1 job categories to 23 SOC-based categories beginning January 1, 2027. You can find the full text of SB 464 by following the QR code on this slide to the California Legislative Information website at leginfo.legislature.ca.gov. What is SB 464? Let us dive deeper into the legal foundation of this law. As stated on the official website of the California Legislative Information at leginfo.legislature.ca.gov, SB 464 was authored by Senator Lola Smallwood Cuevas and is Chapter 760 of the Statutes of 2025. The law transforms California's pay data reporting from a discretionary enforcement regime to a mandatory one. Under prior law, the court had discretion to impose or waive penalties. SB 464 removes that discretion entirely. Upon request from the Civil Rights Department, the court shall impose penalties of $100 per employee for a first failure to file and $200 per employee for subsequent failures. This is a fundamental shift in enforcement. Non-compliance now carries automatic court-ordered consequences with no escape hatch. The law also mandates that demographic data used for pay reporting be collected and stored separately from employees' personnel records. This requirement takes effect January 1, 2026, and is designed to protect employee privacy while still enabling the state to collect aggregate pay data for enforcement purposes. Who must file? Let us talk about employer coverage rules under SB 464. SB 464 applies to private employers with 100 or more employees in California. This includes employees on the payroll as well as employees hired through labor contractors. If you have 100 or more employees hired through labor contractors in the prior calendar year, you must file, and those labor contractors must supply their pay data to the client employer for reporting purposes. Multi-establishment employers must file a separate report for each establishment, giving the CRD a granular picture of pay practices across all locations. Public employers are exempt from SB 464, as are employers with fewer than 100 employees. Tribal government entities and federal government agencies are also exempt. Employers must use a snapshot from a single pay period between October 1st and December 31st of the reporting year to collect their data. What data must you report? The CRD requires detailed pay data broken down by job category, race, ethnicity, and sex. 7 data elements are required. First, employee counts by race, ethnicity, and sex within each job category based on your snapshot period. Second, W-2 earnings reported within the Bureau of Labor Statistics Occupational Employment Statistics pay bands. Third, median and mean hourly rates for each combination of race, ethnicity, and sex within each job category. Fourth, total hours worked per employee counted in each pay band during the reporting year. Fifth, the employer's NAICS code. Sixth, the ownership names of all labor contractors used. And seventh, the snapshot period details. As stated on the California Civil Rights Department website at calcivilrights.ca.gov, you can find detailed templates and instructions on the CRD Pay Data Reporting Portal. Critical deadlines. The first major deadline under SB 464 is May 13, 2026. January 1, 2026 is when the mandatory penalty provisions take effect. From this date forward, courts shall impose penalties upon CRD request with no discretion to waive them. May 13th, 2026, the second Wednesday of May, is the annual pay data report due date for the 2025 reporting year. This report will use the existing 10 EEO1 job categories. January 1st, 2027 is when the 23 SOC-based job categories replace the 10 EEO1 categories. And May 12th, 2027 is the first report due using the new 23 category system. Employers should not wait until the last minute. The data collection and verification process is substantial, especially for companies with diverse workforces across multiple establishments. Penalties. SB 464 fundamentally changes the penalty structure from discretionary to mandatory. For a first failure to file, the penalty is $100 per employee. The court shall impose this penalty upon CRD request. There is no judicial discretion to waive or reduce it. For a subsequent failure to file, the penalty doubles to $200 per employee. Again, mandatory upon CRD request. If a labor contractor is at fault for the failure, the court may apportion penalties to the contractor instead of the employer. All penalties are payable to the Civil Rights Enforcement and Litigation Fund, also known as the CREL Fund. The CRD may also recover its costs in seeking compliance orders from the court. This means non-compliance is not just expensive, it is expensive with no possibility of getting the penalty waived. DEI and data privacy. SB 464 introduces critical new privacy protections for demographic data. Demographic data must be collected and stored separately from employees' personnel records. This requirement is effective January 1, 2026, and requires employers to establish independent data storage systems for this sensitive information. Individually identifiable information is confidential and not subject to disclosure under the California Public Records Act, or CPRA. Individual data cannot be made public before an investigation or enforcement proceeding. The CRD may publish aggregate reports only in a form that cannot be associated with any specific person or business entity. Reports must be retained by the CRD for at least 10 years. This long retention period underscores the importance of getting your data right the first time. The 23 new job categories. The transition from 10 EEO1 categories to 23 SOC-based categories is one of the most significant operational changes under SB 464. Effective January 1, 2027, employers must classify all employees into 23 standard occupational classification-based job categories. These replace the current 10 EEO1 categories that have been in use since the original pay data reporting law. The new categories are far more granular and include chief executives, management excluding chief executives, business and financial operations, computer and mathematical, architecture and engineering, life physical and social science, community and social service, legal, educational instruction and library, arts design entertainment sports and media, healthcare practitioners and technical, healthcare support, protective service, food preparation and serving related, building and grounds, cleaning and maintenance, personal care and service, sales and related, office and administrative support, farming, fishing and forestry, construction and extraction, installation, maintenance and repair, production and transportation and material moving. Employers should begin planning their SOC mapping now. This transition requires significant changes to HR and payroll systems. Compliance roadmap. Here is a 7-step plan to prepare for the 2026 reporting deadline. Step 1. Audit your workforce data systems. Make sure you can extract race, ethnicity, sex, W-2 earnings, and hours worked for each employee in your organization. Step 2. Set up separate demographic data storage independent from personnel records. This is a legal requirement effective January 1, 2026. Step 3. Prepare your snapshot from a single pay period between October 1st and December 31st of the reporting year. Step 4. Map employees to job categories. Use EEO1 categories for the 2026 report, but begin preparing for SOC-based categories for the 2027 report. Step 5. Verify your NAICS code and collect labor contractor ownership data if applicable. Step 6. Submit through the CRD Pay Data Reporting Portal before the second Wednesday of May. And Step 7. Document everything. Maintain thorough records of your methodology, data sources, and compliance efforts. Key takeaways. Let us summarize what every California employer with 100 or more employees must know about SB 464. Number 1. SB 464 makes penalties mandatory. Court shall impose $100 to $200 per employee for non-compliance, with no judicial discretion to waive them. Number 2. The first pay data report under the new rules is due May 13, 2026, using the current 10 EEO-1 categories for the 2025 reporting year. Number 3. Demographic data must be stored separately from personnel records by January 1, 2026. This is a new data privacy mandate that requires immediate action. Number 4. 23 SOC-based job categories replace 10 EEO-1 categories effective January 1, 2027. Begin planning your SOC mapping now. Number 5. Confidentiality protections prevent CPRA disclosure of individual data. Only aggregate non-associable reports may be published by the CRD. Number 6. The CRD must retain all reports for at least 10 years, and penalties collected fund the Civil Rights Enforcement and Litigation Fund. And number 7. Consult the CRD Paid Data Reporting portal at calcivilrights.ca.gov/paydata reporting and your employment attorney for specific compliance guidance tailored to your organization. Thank you for watching this presentation on California SB 464. Remember, this presentation is for educational purposes only. Always consult qualified legal counsel for advice specific to your situation.